You're all welcome to today's class, and today we are going to talk about the law of agency. Okay, the law of agency is a type of law which most corporations use in execution of their businesses. Big companies cannot be able to reach every one of their customers, so what do? They engage agents to help them in their businesses. When we talk about big companies like banks, like communication companies, like insurance companies, they always use agents in execution of their businesses. So allow me to take you through the law of agency. Don't hesitate to subscribe on my YouTube channel, for there are many more videos in regard to law. So you're all welcome. You're all welcome. Let's begin by making some definitions. I want to begin by defining agency. That it's the legal relationship that arises when a person called an agent is appointed or entitled to represent another called a principal in a transaction with some other person called a third party. And now we want to define an agent. And we're going to define an agent from Housebury's Laws of England. Housebury's Laws of England, 3rd edition, defines an agent as a person employed for the purpose of placing the principal in contractual or other relations with a third party. Now, in Uganda, the leading law in relation to the law of agency is the Contracts Act 2010. And under section 118 of that act, an agent is defined as a person employed by a principal to do any act for that principal, or to represent the principal in dealing with a third person. A principal is a person who employs an agent to do any act for him or her, or to represent him or her in dealing with a third person. A sub-agent is a person employed by and acting under the control of an agent in the business of the agency. So a sub-agent is employed by an agent to help him in execution of the business he was trusted with by the principal. I hope you're all following. Now I want to talk about capacity. And number one, we are going to begin by talking about who can be a principal. Who can employ an agent? And this is reflected upon under section 119 of the Contracts Act, which states that a person may employ an agent while that person is 18 years or more. B, is of sound mind. You need to be in your right thinking faculties to employ an agent. A mad person cannot give instructions to an agent. This is what that is all about. C, is not disqualified from appointing an agent by any law to which that person is subject. Number two, we want to talk about capacity to act as an agent. Who can be an agent? What are the qualifications to being an agent? And those are reflected upon under section 120 of the same act, that is the Contracts Act. That a person may act as an agent where that person A, is 18 years or above. The age of majority for Uganda is 18 years. That is the recommended age of majority under the Constitution of the Republic of Uganda, 1995. B, is of sound mind. And C, is not disqualified from acting as an agent by any law to which he or she is subject. So I want to talk about the different types of agencies. It is important for you to appreciate, or it's important for you to apprehend the types of agencies and how they come about. How they come about. It's important. A, we have what we call express appointment agencies. And we can briefly note that this kind of appointment may be oral or written. It may sometimes be partly oral or partly written. Someone can orally pick on you to be his agent, or he can give you a document giving you instructions to act as his or her agent. Sometimes it's a power of attorney. Someone gives you a power of attorney to act on his behalf. So that's what we mean by express appointment. Number 2 is what we call the doctrine of estoppel. Someone can become an agent out of the doctrine of estoppel. And we can briefly note that this is the type of agency that arises from the principle of holding out. It arises from the principle of holding out. Holding out means someone acting as if he is part of the company, yet he is actually not. But you find that that someone is so involved in the business of that company to the extent that he's even known by the owners of that company. And they even go ahead and execute business with him. That is what we mean by holding out. So if he's involved with a third party and something bad happens, he is also part of the people to blame. He's liable under the doctrine of estoppel. And we're saying that a person who is under a legal duty to inform a third party that the person purporting to act for him as his agent is in fact not his agent, but fails to do, may be stopped from saying that the apparent agent is not his agent. C, ratification. That this is a type of agency that arises if a person adopts a transaction which someone had concluded for him as his agent, but without his express authority. Without his express authority. Letter D, agency may arise out of necessity. An agency of necessity may either be commercial or domestic. And under necessity we have 1, commercial agency. At common law, a person who is entrusted with perishable goods of another is entitled in certain circumstances to do certain things in relation to the goods as if he had been expressly authorized to do so by the owner. Very true. And there is also domestic agents of necessity. And we're saying that at common law, a married woman becomes an agent of the husband and can take necessaries on credit for her personal use. Can take necessaries on credit for her personal use. Because when two get married, biblically they become one. So the husband becomes the principal and the wife can become an agent of the husband. So briefly, let's look at the duties of an agent. And these are reflected upon under the Contracts Act and include the following. 1, the duty to follow the principal's directions. That is under section 145. Number 2, the duty to carry out the work with reasonable skill and diligence. And that is under section 145. Number 3, the duty to render accounts. And that is under section 147. Number 5, the duty to communicate. You're supposed to communicate with the principal as an agent. Another one, the duty not to make any profits out of the agency, secret profits, without the knowing of the principal, and that is under section 150. Then another one, the duty to protect and preserve the principal's interests upon death, that is under section 143. And lastly, under duties of an agent, the duty not to delegate, that is under section 126.4. Very good. So briefly, let's look at the duties of a principal, the role he has to play in regards to the law of agency. Number one, to remunerate the agent upon completion of work. You're supposed to pay someone for a job well done. That is under section 153. Number two, to indemnify the agent against consequences of lawful acts. That is under section 156.1. Number three, to indemnify the agent against consequences of acts done in good faith. Number four, to compensate the agent in case of an injury or any loss. Lastly, under the law of agency, we want to know how this relationship comes to an end, can come to an end. And that's what we mean by termination. And this is reflected upon under section 135 and includes the following. Revocation by principal, when the principal is no longer interested with continuing with the agency relationship. That is under section 135A. Renunciation by agent, when the agent is no longer interested in the relationship. That is under section 135B. Completion of business or work, meaning that you shake hands and part ways because the job has been done. That is under section 135C. Death of principal or agent. Once one dies, you cannot continue the relationship with his spirit. The only thing that can happen is for you to close the business. Then unsound mind of either the principal or the agent. Insolvency of principal. When the principal runs bankrupt, it means that he cannot continue running the business or the relationship because he will not be able to pay the agent. So the best way would be to call off the agency relationship. That is under section 135D. F. And then consent or agreement. The two parties in the relationship can agree on how the agency relationship can come to an end. And then lastly is frustration. And that is under section 135. Meaning that an act can happen which is out or beyond the control of both parties. For example, if A instructs B to sell his house, and before B sells off the house is involved in a fire. That fire is an act of frustration which ends up frustrating the business, and then the two parties can terminate the agency. Once again, I would like to thank you for the time you've spent watching this video, and may the good Lord bless you all.